This girl was celebrating her 22nd birthday. Cops showed up. They ended up slamming her down onto the ground. She was injured. She filed a lawsuit. It got litigated for 7 years, went all the way up to the 10th Circuit. It just settled a couple days ago.
He's not free to go, but you can keep walking. Back off.
No, I'm going to stay here.
No, ma'am.
You don't need to touch me.
I don't want to throw you on the
What
ground.
did I
Please
do?
don't do that.
What did I do?
Please don't do that.
Okay, I'll put my hand behind my
Put
head.
your hand up on your head right now.
Hey, what the did I do?
Ma'am?
What did I do?
Before I give you all the answers, which I will, which will give you a better understanding of the law of excessive force and how qualified immunity applies to that, I want you to put in the comments your prediction about whether or not this is a constitutional violation, whether or not this police officer gets qualified immunity, and does this woman deserve to be paid? If so, how much? If not, why not? Let me know in the comments. All right, let's go through it. And just to be clear, the description of this video that I'm about to give you and the law as it applies to it is straight out of the federal court opinion. It's undisputed. In April 2017, Miss Surratt was celebrating her 22nd birthday at a bar in Fort Collins, Colorado. At approximately 11:12 p.m., two Fort Collins police officers, Officer Garrett Pastor and Officer Clamser, were dispatched to the bar in response to a reported disturbance involving Miss Surratt's then-boyfriend, Mitchell Waltz. While Officer Pastor spoke with Mr. Waltz, Officer Clamser spoke with the bar's bouncer. Miss Surratt attempted to exit the bar and, quote, lightly bumped Officer Clamser as she walked past him.
So I can bring Tyler out here. Okay. He said that he'd had to tell this guy multiple times to get off him. He kept bumping into him. On Tyler? Yeah, our security guy. Kept bumping into him. Excuse me?
Miss Surratt approached Mr. Waltz and tried to walk away from the scene with him. Upon learning from the bouncer that Mr. Waltz was involved in the disturbance, Officer Clamser yelled to Officer Pastor that Mr. Waltz was not free to go.
Hey, he's not free to go. He's not free to go, but you can keep walking.
Officer Pastor began interviewing Mr. Waltz, and Miss Surratt tried to walk towards Mr. Waltz. Officer Clamser, quote, standing 6 feet tall and weighing approximately 200 pounds, blocked the 115-pound Miss Surratt from obstructing Officer Pastor's interview.
Back off.
No, I'm going to stay here.
No, ma'am.
You don't need to touch me. You don't need to touch me. You don't need to touch me. Why
Put your
are you
hand on your head.
touching me?
Put your hand upon your head, because you're under arrest. You're under arrest.
Touching me?
Put your hand
No,
up.
explain to me why you're
Ma'am,
arresting me.
ma'am.
What did I do?
I don't want to throw you on the
What
ground.
did I
Please
do?
don't do that.
What did I do?
Please don't do that.
Okay, I'll put my hand behind my
Put
head.
your hand up on your head right now.
Hey, what the fuck did I do?
Ma'am?
What did I do?
He placed Miss Surratt under arrest and held her by her wrist. In response, Miss Surratt attempted to pry Officer Clamser's fingers off her arm and pawed at his arms. Officer Clamser then used a takedown maneuver, throwing Miss Surratt to the ground to subdue her.
I don't want to throw you on the
What
ground.
did I
Please
do?
don't do that.
What did I do?
Please don't do that.
Okay, I'll put my hand behind my
Put
head.
your hand up on your head right now.
Hey, what the did I do?
Ma'am?
What did I do?
Miss Surratt, quote, sustained a concussion, cervical spine strain, contusions to her face, and bruising on her arms, wrists, knees, and legs.
I'm not resisting. I'm not resisting.
Hold on
I'm
your
not
shirt.
resisting, please. I'm not resisting, please.
Is there a car here?
I'm not doing anything.
Sure.
Are you kidding me? I'm not doing anything.
Edward
I'm not
276.
doing
We need a
anything.
transport car to
I
Lincoln
was
at Walnut.
trying to get my boyfriend. Are you
This
fucking
way.
kidding me?
Yep.
Oh my God.
After the incident, Miss Surratt was charged with obstructing a peace officer and resisting arrest. Miss Surratt pleaded not guilty to both charges and asserted a theory of self-defense, arguing she used physical force against Officer Clamser to defend herself, quote, from what a reasonable person would believe to be the use of unlawful physical force. The jury rejected her theory of self-defense and ultimately convicted her of both charges. In March 2019, Ms. Surratt filed a federal civil rights lawsuit alleging Officer Clamser violated her constitutional rights by subjecting her to excessive force during her arrest. She alleged that in making the arrest, Officer Clamser used greater force than would have reasonably been necessary to effect the seizure by, among other things, pulling her arm by her wrist and throwing her face first into the sidewalk. After the lawsuit was filed, Officer Clamser asserted qualified immunity. The case went all the way up to the U.S. 10th Circuit Court of Appeals. They took a look at the case, they watched the video, and this was their conclusion. Ms. Surratt was arrested for 2 misdemeanor offenses committed in a particularly harmless manner. She did not pose a threat to Officer Clamser or others after he initiated the arrest, although she did minimally resist arrest. Officer Clamser's alleged use of force against Ms. Surratt using a takedown maneuver to slam her face into the ground was not proportionate given her level of resistance. And we therefore hold that the use of the takedown maneuver to slam to the ground a non-violent misdemeanant who poses no immediate threat to the officer or others based on minimal resistance to arrest is unreasonable and constitutes excessive force under the Fourth Amendment. In reaching that conclusion, the 10th Circuit went over the Graham factors, which, as I've explained in numerous videos, are 3 different factors. 1, the severity of the crime at issue. 2, whether the suspect poses an immediate threat to the safety of the officer or others. And 3, whether she is actively resisting arrest or attempting to evade arrest by flight. Regarding the first Graham factor, the severity of the crime at issue, the court held that it favored Ms. Surratt because her conduct of resisting arrest and obstructing a peace officer were not severe crimes. In Colorado, obstructing a peace officer and resisting arrest are both Class 2 misdemeanors. Although both crimes may be achieved by violent means, taken in the light most favorable to Ms. Surratt, a jury could conclude that she committed both crimes in a particularly harmless manner, where the only physical force she used was attempting to pry Officer Clamser's fingers off her arm and pawing at his arms. Because these are misdemeanor offenses and a jury could find that they were committed in a non-violent manner, the amount of force used should be reduced accordingly. Here, Ms. Surratt's misdemeanor offenses weigh against Officer Clamser's use of the takedown maneuver during her arrest. The second factor, whether the suspect poses an immediate threat to the safety of the officer or others, is undoubtedly the most important and fact-intensive factor in determining the objective reasonableness of an officer's use of force. The court must look at whether the officer or others were in danger at the precise moment that they used force. Ms. Surratt did not pose an immediate threat to Officer Clamser or anyone else at the moment Officer Clamser slammed her violently to the ground. Instead, it was undisputed that Officer Clamser held Ms. Surratt by the wrist, she was unarmed, and she weighed 85 pounds less than Officer Clamser. Although Ms. Surratt used minimal physical force against Officer Clamser by attempting to pry his fingers off her arm and pawing at him, this did not place Officer Clamser or others in any immediate danger. And under these circumstances, Ms. Surratt posed a minimal safety threat at the moment Officer Clamser threw her to the ground, and so the second Graham factor weighs against Officer Clamser's use of a significant amount of force. As to the third factor, the court evaluates whether the suspect attempted to flee or actively resisted the arrest. Ms. Surratt's resistance to arrest is conclusively established by her conviction. The court has explained that where a plaintiff acknowledges that she was actively resisting arrest, there is no doubt that officers are justified employing some force against the plaintiff. The level of Ms. Surratt's resistance, attempting to pry Officer Clamser's fingers off her arm and pawing at him, does not justify a severe use of force in response. Accordingly, although this factor does weigh in favor of Officer Clamser reasonably using some amount of force against Ms. Surratt to overcome that resistance that she provided, his use of force had to be proportionate. Thus, the 10th Circuit weighed this factor as providing support for the use of a minimal amount of force. Thus, as a matter of law, the U.S. 10th Circuit Court of Appeals held that Officer Clamser, in the takedown that you see on the video, violated the Fourth Amendment, That is undisputed. But the problem with qualified immunity is that it applies in those scenarios where the Constitution has been violated. The issue is whether or not the officer gets immunity. And that's what ended up happening here. Although the court held this was a Fourth Amendment violation, excessive force, they said in April of 2017, a reasonable officer would not have known that using a takedown maneuver such as this to throw Miss Surratt onto the ground while she was resisting arrest for a nonviolent misdemeanor and not posing a danger to Officer Clamser would not violate the Fourth Amendment, which is sort of insane. She wasn't able to point to a case where the facts were close enough that was earlier in time than when the incident happened. She put forth 5 different cases, but they were from other circuits, and then 3 unpublished 10th Circuit cases. So one of the cases was Shannon versus Kohler, and in Shannon, when the officers responded to an altercation at a bar, which is similar, the plaintiff strongly stated to one of the officers using profanity that he owned the bar, did not need the officer, and ordered the officer to get out of the bar. The officer alleged that the plaintiff poked him twice in the chest. The officer then performed a takedown, which caused the plaintiff to hit a bar stool and land on the floor. But this was the 8th Circuit. The 8th Circuit concluded, though, it was not reasonable for the officer to use more than a de minimis force, bare minimum, against the plaintiff where he was not suspected of committing a serious crime, did not attempt to flee or actively resist arrest, and posed little to no threat to the officer or others. But importantly, the 8th Circuit there concluded that a jury could find the plaintiff and Shannon did not resist arrest, whereas here, Ms. Surratt was actually convicted of and admitted to resisting arrest. So that case is distinguishable. And the court basically went through the others, shot them down one by one. You can review all of those. I will post the full opinion at the blog linked below. The point is that the 10th Circuit said none of the precedent, none of the prior opinions identified by Ms. Surratt would have made it clear to every reasonable officer that throwing Ms. Surratt to the ground in response to her minimal resistance would violate the Fourth Amendment. And as a result, Officer Clamser is entitled to qualified immunity. One silver lining there, this order was entered November 9th, 2022. So from that date through now, anyone who has been thrown to the ground by a police officer in the 10th Circuit in response to what's arguably or alleged to be minimal resistance, they could get past qualified immunity using Ms. Surratt's case. Despite the fact that this officer got qualified immunity, just a couple of days ago it was announced in the media that the city of Fort Collins had agreed to pay Ms. Surratt $300,000 after 7 years of battling this lawsuit in court. But Fort Collins Chief of Police Jeff Swoboda said that was not the city or the agency admitting any wrongdoing. This settlement is a situation where we chose to avoid the continued expense and ongoing disruption of litigation that has ensued over the past 7 years and was unlikely to be resolved even after the scheduled district court trial. Swoboda said the agency always reviews prior interactions with the community to learn, and the agency adjusts its practices when necessary. However, it was not made clear whether or not the agency made any direct changes to its use of force training when it comes to Surratt's specific case. If the officer got qualified immunity, why wasn't the case over? Why wasn't it settled? Well, the reason probably is because the plaintiff also asserted what's called a Monell claim. A direct civil rights violation always has to be asserted against an individual, the individual officer. So that is the defendant in the case. You can sue a city or a county under what's called a Monell claim, but it's not like the private economy where you can sue Walmart for the actions of their employee. Government does not let us do that. You have to specifically allege that there is a unconstitutional policy, pattern, practice that directly caused the event that was committed by their employee. So a very, very tough case to make. Guess what? A city cannot invoke qualified immunity. It's not a defense to a city. But the problem with that is it's very, very difficult to prove. That probably was still left hanging out there. Apparently that was worth $300,000. The city of Fort Collins, Colorado, as we sit here today, cannot deny that that video shows one of their police officers violating this woman's Fourth Amendment rights. That is the law now. That's the law of the land. in Colorado in the 10th Circuit. The court actually looked at it. They watched the video. They declared that to be an unconstitutional act, slamming that woman down to the concrete. And henceforth, any police officer who does it again will be denied qualified immunity. Unfortunately, the officer in this case got away with it. So when the city of Fort Collins says that we're denying any wrongdoing, notice that they parse their words carefully. They don't say that the officer did nothing wrong. They're saying we did nothing wrong. Have they changed anything in their policy? I mean, they defended this guy for 7 years. Did they discipline him? Do they take any responsibility for getting to the situation where, a court one step down from the Supreme Court of the United States says that their employee violated this woman's constitutional rights, which supposedly he took an oath to protect? They hid behind qualified immunity for 7 years. They don't admit to have changed anything. Instead, they paid out $300,000. And that settlement amount, in my opinion, is a good one. I mean, the main stronger claim against the officer got thrown out. That wasn't going to trial. The officer was out. So it was the only claim left in is the Monell claim against the city. As I said, those can be very, very difficult. But let me know what you think in the comments. Again, this is one of those situations where, everyone can have their own opinion, but none of this can be disputed. That video shows an excessive force violation. Nobody can dispute that. That's the law of the land. That woman ended up getting $300,000 in the end. That's what happened. Nobody can dispute that. But yet the officer did get qualified immunity here. Nobody can dispute that. It just sort of illustrates the absurdity of the whole qualified immunity doctrine, does it not? So thanks for watching. You like to go through these sorts of things. Please make sure you subscribe and check to see that you're still subscribed. Every day people are telling me that YouTube keeps unsubscribing them. And they've had it happen 10 or 15 times. I'm sure that's an aberration because the channel has definitely been growing. So I'm not saying YouTube is purposely doing that at all. But just check it if you enjoy this content. Remember, our rights don't end where your fear begins. Freedom is scary. Deal with it.